You know, a lot of people hear secret grand jury process as part of American jurisprudence, and they think, why would we do that? Why would we have secret grand juries? I mean, all grand juries, right? Secret. You do not get to know. Defense doesn't even get to know. They don't get in there. They don't get to cross-examine. Nope. It is a prosecutor's process, and it's their prerogative to either have a grand jury or to have an open preliminary hearing. And all along we thought there'd be a prelim, but then boom, yesterday, turns out there's been this secret grand jury meeting and they got the indictment yesterday on Bryan Kohberger. Think about it this way. When mobsters are being tried and witnesses are terrified for their life because someone else in the family of organized criminals is gonna off them, the secret grand jury is a good thing, right? They can help get that person to trial without, coming forward and having their lives threatened. So it's not a terrible thing. What's terribly sad is that in this case, that the judge actually thought that some of these witnesses would be harassed in person, on social media, and that they'd get harassment, intimidation, and threats. I mean, that's really, really sad in this case, because that guy's not a mobster, but what is going on with the interwebs and people who are threatening these poor witnesses? I want to bring in somebody who knows a lot about this. It's Richard Blok. He's a criminal defense attorney practicing in Idaho. So, Richard, there's some discrepancy on whether some people think that he's waived his right to a speedy trial because he said, I'm fine to wait 6 months before a preliminary hearing and then, an indictment. But the law in Idaho says a suspect must be tried within 6 months from arraignment unless they waive the right to a speedy trial. So presuming he hasn't actually waived speedy trial, he just waived the prelim, that would put his 6-month date at November 22nd, the Wednesday before Thanksgiving, and right around the anniversary, of the murders. There is not a chance that anybody could go through 51 terabytes of material before Thanksgiving.
Yeah, there's no way that that's happening. I think that there's both that 6-month rule, but the judge can continue the case for what's called good cause as well. And I'm sure we're going to see quite a bit of that here. I would assume that we're years away from trial in a case like this. Just an average murder case takes more than 6 months to get to trial. A case with 51 terabytes, which is a mind-numbing amount of data, is going to take more than that.
Yeah, Lori Vallow may have underestimated the whole strategy of a speedy trial. Didn't work out so well for her in Idaho. So the defense, would they have been aware of the grand jury meeting? And as a secondary part of that question, are they changing their strategy in this case now, knowing that they did not get this advance ability to cross-examine witnesses and figure out what those witnesses are going to say eventually when he goes to trial?
So they were probably aware of this. You got to remember that this is the local county public defender. They're incredibly well connected in that courthouse. I would be shocked if they hadn't heard rumors of it at the very least. And whether they're going to change their strategy, we don't know, because we don't know what the discovery looks like. We don't know what the evidence looks like. As a defense attorney personally, I like cross-examining witnesses at preliminary hearings. It's a great way to find more information for your investigation. Usually you don't have 51 terabytes. Usually you have a very small amount of information. You're actually looking for more. So it's a great way to develop information there at preliminary hearings. That being said, we'll see if what they're going to do with this. They are going to get all the transcripts. They're going to get all that information from the grand jury, and they'll go from there.
Can I ask you, in this age of, digital media, and these were, kids who were big into digital communication, is this new? I mean, is 51 terabytes sort of like, yeah, that's where we're going, Ashleigh? Like, we all have to kind of figure out this new world of navigating that much data in discovery? Or is this like bad faith, overdumping to try and make it hard? I just worry about the Idaho taxpayers who are footing the bill for both the prosecution and the defense.
Right. This is, we're definitely seeing bigger and bigger amounts of data in even really small cases. I currently have a misdemeanor case where I got 10 gigs of data in it, which is nuts for a misdemeanor. I think this is going to become more and more common. I don't know that it's just a dump to try and bury the defense, because the defense is going to need to ask for more resources. They're going to ask for more time. This is a complex case with lots of digital forensics in it, lots of video from lots of different sources. It doesn't surprise me that there is a tremendous.
Which guarantees that you're going to get repeated invitations back on this program. Richard Blok, thank you for that. Appreciate it. Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.